This is Paul Hitchcock. Harry and Bill, are you there?
Paul, how are you?
Good. We're right at 11 o'clock, so we're going to jump right into this. I want to thank everybody for joining our webinar, and I'm really excited to have Bill and Harry on the webinar. My colleagues here at BarthCalderon, we are an asset protection, estate planning, and business planning firm. Harry Barth is our founder and senior managing partner, and is a top expert on asset protection, business planning, and estate planning, and is a top speaker across the country to many incredible groups, including Vistage, Tiger 21, the California Apartment Association, and many, many others. And so Harry's going to be delivering some very unique content today that he delivers across the country to these groups. Bill Black, my colleague, is the founder and host of Exit Coach Radio, which is a phenomenal and huge podcast and radio show broadcast from Los Angeles. And Bill, over the years, has helped over 1,000 business owners on the growth, succession, and exit with their businesses. So we're going to jump right into it. Harry, I think I'm passing it over to you, and thanks so much.
Well, I appreciate it. Hi, everybody. Good morning, and thanks for being with us this morning. Just a little bit of an overview of what we expect to cover today. Bill's going to be talking to you a lot about succession, exiting your business. And for many of you, your business is your most valuable and most important asset. One of the issues the issue that I'm going to be bringing to your attention today is, yeah, it's really important to have great succession and have great value with that company. But if we don't protect the company and protect the business assets that we have, we could be succeeding to nothing. So so I'm going to give you some tools and some techniques along the way and talk a little bit about asset protection for businesses on a very, very overview basis today. And Bill is going to be talking to you about the following items. So Bill, why don't you jump in and let us know what you're going to be covering today.
Well, thank you, Harry. Thank you, Paul. For the last 35 years, I've worked with really hundreds and hundreds of business owners, and I keep hearing the same things over and over again. I set out to own my business, but I feel like my business owns me. I don't really have a clear vision for my exit. I don't see what that's going to look like. And I'm worried that something could happen that could derail this whole train that I've built. I've had clients that have died and left their family in a world of hurt. I've had clients that have bet everything on selling the company only to find out it's not worth nearly what they thought it was worth. I've had owners that assumed family members would take over only to find out they don't have the aptitude or attitude, which often results in unhappy Thanksgivings, which is something you don't want. And I found that it's critically important to make sure your plan is built like a pyramid with a strong foundation. And that's what I'm going to cover today is the 5 levels of that pyramid. So I'll turn it back over to you, Harry, so we can get into asset protection planning.
Okay, so when we talk about asset protection, everybody, you know, this just has so many meanings to so many different people. But inherently what it is the organizing of your affairs and your businesses in such a way to have it the most protective in the event that we have a attack by overly zealous creditors and or predatory attorneys. Now, I think it's very important to understand that there are 3 axioms in asset protection planning that are critical to all of us. And the most important one of all is that you don't engage in asset protection planning after the fact or after the event. We see this all the time where people will be calling our offices. We've been at this for 4 decades, you know, saying that X event has occurred and what can we do to help them? And I think it's very important to understand that although there are things that we can do to help people who are in trouble, for asset protection planning to be functional and work properly, ethically and professionally, we need to do it beforehand. We get, you know, crazy things like, well, what if I divorce my wife? What if I give everything to my kids? Anything being done after the event could be considered to be avoidable conveyance and could be lost. Second important truism of today is that living revocable trusts, you know, the trust that we do for estate planning for ourselves, for our children, for our families, those trusts, a lot of people don't recognize, have no asset protection characteristics whatsoever. In the event where it should be the businesses or the LLCs or the corporations are inside the trust, a lot of people think that that trust provides some modicum of asset protection. If you can reach the assets, so can a creditor. And then the third thing that's really important is that insurance. I think it's very important to have insurance, a complete and comprehensive insurance program, covering as many gaps as we possibly can. So we have a place to drive a plaintiff to in the event that one of the events that could visit upon you actually does occur. So I think that insurance is very, very important, but I think it's also very important, ladies and gentlemen, that insurance is not the know-all, end-all, and I will explain that as we move throughout the morning together. So why don't we go back to you, Bill, and tell us a little bit about succession and business planning.
Yeah, I agree with everything you say, Harry. The type of insurance you're talking about typically is the property casualty side, but we also specialize in looking at situations where the role of life insurance was either overlooked, misunderstood, or misused. When we're talking with business owners who say, well, again, I'm afraid that the whole thing's going to unwind on me before I get that taken care of, we find that that's often a good solution. So let's talk about that. Our first level of our pyramid is the base. And you know how a pyramid looks. It's skinny at the top and fat at the bottom. But basically what you want on that first level is your continuity and contingency planning. And we find that business owners oftentimes overlook that. They say, I'll get to that someday. And again, we've had owners in the midst of growing fabulous businesses who ignored this, and then something happened. I had one particular client who was working out of all things and had a heart attack and died and left the business in a big mess because he didn't talk about the continuity planning. And in a lot of ways, this is where you get involved with attorneys like Harry. This is where you're going to have your living trust set up, all of your asset protection set up, your business, something we call business continuity instructions, which some people call the business will. Everybody knows what a will is, but what happens with your business? What are the nuances that somebody should be able to come in, read a couple-page document and say, okay, this is what this individual wanted to happen to the business. These are the people that they trusted who can come together and help run the business. And this is basically who we can talk to maybe buy the business if that's what we want or turn the business over to. So level one, the continuity and contingency plan, which is critically important. And again, I rush to this first when I talk to a business owner because all the other planning we do could evaporate if we don't have a strong base. So it's instructions, advisors, and insurance. That's level one of your basic overall plan. So Harry, let's go back to you.
Yeah, and try to come across with some ideas to be helpful to everybody. So there's some meat that can be taken away from today's webinar. One of the concepts, or the first concept that I'd like to talk about, is the form or the entity by which we do business. Again, what Bill is talking about, this plays together so well in the fact that, we have no value if the business has been hammered. We've seen businesses lost as a result of lawsuits. There's nothing to succeed to. So we have our precious asset. Now let's talk about our precious asset. And this is something that we see quite frequently. Now, business owners have to recognize that you have two forms of liability. One is a liability that's coming, what we call an outside-in liability, which is a liability that comes to the owner of the entity. So this is not related to the work of the entity, but to the owner of the entity. And then we have liabilities that come to the entity as well. So we have, that's called inside out, and the other one is outside in. So one of the interesting statistics is that more businesses are lost to outside in liability than to almost any other cause. So what happens is there's a liability to the owner of the business or the owners of the business driving a car coming from a real estate operation, coming from another business that they own. They get in trouble. A judgment comes against them, and then we look down at what assets can we take away from them. Now, many businesses, or small to medium-sized businesses in the United States, are organized as corporations. And while corporations are effective for inside-out liability, but not as effective for outside-in liability. So the bottom line is that we own a business, or you own an S corporation, a C corporation, there's a liability to the owner. The creditor is able to take the stock of the company in order to satisfy the claim. So when they take the stock, the managerial control would shift to the creditor. The creditor can liquidate the business. The creditor can sell the business to a competitor. The creditor can even operate the business. In all intents and purposes, the business is lost and gone. I think it's really important to understand that if it's possible, and in most cases it is, we can change the form of the business into a limited liability company in a state that has very favorable rules and register it in the state in which you do business. And by structuring an appropriately structured limited liability company, the remedy to the creditor will change. And the change is that the creditor may be able to place a lien, known as a charging order, over the distributions that come out of that business, but the creditor would get no managerial control, can't even force a distribution, can't reach inside and touch the assets, so the business remains safe. We still have a business while we attempt to work out and negotiate a solution to our problems. So to me, why would anybody continue to operate a business or businesses in a fashion where that business can be lost, or they can operate that same business probably even more economically if by changing its character? And just one last thing before we switch back to Bill on that. A lot of people feel, or some CPAs will tell them, that if you change from the corporate format to the LLC format, that's the same as if you sold your business and started a new one, which has a terrible tax outcome. What we're talking about here in situations where we're switching from the corporate form of business and that's all its required formalities to an appropriate designed LLC is use of what we call a Plan F reorganization, which will allow us to reorganize the business into a limited liability company, but keep the business 100% the same as it was for tax purposes. It'll be taxed as a C corporation or an S corporation, so there'd be no adverse tax consequences. So less ministerial things to worry about, taxation exactly the same, and you now have a business that you can never, ever lose managerial control of. It's structured properly. I think that's very critical and very important. Bill?
Absolutely important. Absolutely important. You know, we spend a lot of time talking about these issues, and a lot of business owners have said, and I've heard them say to you, Harry, you know, why didn't my other advisors tell me this stuff? I mean, they just rushed to help me. And the reason is I think a lot of advisors are trained to do what you want. And the problem is sometimes you don't know what you want, and you need somebody to help you say, hey, did you know that you've got this problem or this issue? And we don't hesitate to help you understand what some of those things are. In my level 2, as I work up the pyramid, after you've built that solid foundation, your structure, your continuity plans, is really starting to think about how the business can run without you. So I put a couple acronyms in there, SOP, which is your standard operating procedures. And I'm surprised at how many business owners say they have standard operating procedures, but they can't produce them. It's in my head, or we wrote them down a long time ago. We don't know where that manual went. There's nothing for someone to come in behind them and say, okay, I see how you do this. It's step by step. And so business owners that feel like they're trapped in their business or forever trapped in their business if they don't have standard operating procedures so they can hand off what they do. Not only what you do, but what your key people do, because if you don't know what your key people do and how they do it, they can hold you hostage either now or down the road. Second is your CRM, and that's your client relationship management program. That's where all the data on all of your clients is, what they've ordered, how they like to be addressed, who their kids are, you know, all the things that make your relationship nice with your customers who are the lifeblood of your business. And so many people, again, have it in a spreadsheet, or they have it written down, or it's in their head, even worse. So it's putting together those business documents and tools and strategies so that you're building a business that can be run someday without you, so that it is saleable, so it is valuable, so it is transferable. So I do a lot of work with business owners in helping them identify what those things are that they need to set up so that their business can someday be worthwhile and transferable to someone else. And the other thing that goes into this segment is developing your overall exit plan. And again, an exit plan isn't for exiting tomorrow. It's for thinking about what you need to do in the next 5 years, maybe 3 to 5 to 10 years, to help make sure that you're not having to do a lot at the last minute when someone comes at you. And I know a lot of you have received phone calls and letters and invitations from M&A people that say lots of wonderful things about how they want to pay top dollar for your business. So you need to figure out, is this a good offer or is this a bad offer? What are my terms? What's going to make me whole? So I tell people there's two values that you need to know at all times: your current value of your business and what you need your value to be down the road. And that takes some planning to figure out what makes you whole, what would get you home if you needed to walk away from your business, so you can determine whether you're getting a good offer worth talking to or something you should just hang up the phone and move on to the next task you need to do to make your business valuable. Harry?
Well, very good. And, and just tailing off of what Bill just said, I think it's very important, besides standard operating procedures, there are other factors that I think are very important. One, to help increase the value of the business and to protect the business. Although these seem to be ministerial, they're not. So, for example, when we talk about asset protection, we can't help but avoid the conversation about insurance. So we want to make sure that a comprehensive insurance review is done, that we understand what the gaps are, what coverages we have and we don't. We have so many people who've been surprised constantly when a wage and hour claim comes or a different claim comes, that they find that or sexual harassment claim, they don't have any coverage at all because it wasn't covered under their basic business policy. So a lack of comprehension about the insurance, I think, is that ignorance is a terrible characteristic that leads to asset protection nightmares. The other thing to understand is that when we talk about insurance in the insurance arena, is that not everything that happens to us will be covered by insurance. If that was the case, the insurance policy would be 1 page long instead of 65 pages of covenants, conditions, and restrictions to see whether or not the insurance company is going to provide coverage. And examples of that are exemplary, special, and punitive damages are not covered by any insurance whatsoever, and it should be involved in any of those types of behaviors, and those behaviors, especially example in California, have become so much more prevalent that we may not have coverage, and they'll be looking to our personal assets. Now, the other comprehensive component is what I call a legal audit update and review. It's amazing. If I was a buyer of a business and I came into the business and the files were in disarray and the contracts were in disarray and the other contracts were by handshake and all of the various different legal components, or maybe even the company itself is not in good standing anymore in the state where it's registered, or it's missing its annual minutes and its review, I can assure you that my price for that business is dropping logarithmically as I begin to see that. On the other hand, if we have a business that is engaged in an appropriate and proper legal audit and review, and all the contracts are proper and they're dated and all the amendments are done and all the compliances and complaints, you look at that and say that's a well-run, well-operated business, and it's easy to find all the due diligence necessary to get things done. I can assure you that will add 10 to 15 to 20% to the value of the business at the same time by the buyer. So those are two, simple, ministerial, but somewhat time-consuming things that should be done by every single business. A comprehensive legal review, a great insurance review as part of the preliminary steps in their asset protection. And then, of course, back to how we structure the business. And I'll be back to you in a little while with an example of another structural gem that I will give to you. Bill?
Yeah, those are great tips, Harry. Let's face it, your best assets go home every night. Those are your key people. They're not on your balance sheet, but they should be. The issue that we find in my level 3 is key person retention and protection. And basically, there's 4 steps to it. Identify, is someone key? Is a person key to your business? That is, can they run the business in your absence? And I have a real problem with this. Sometimes people say, well, so-and-so's pretty good, but, well, are they key, or is their position key? You may or may not have that. The person may or may not be key, but a lot of times they do. They have the knowledge. They can actually go out and destroy your business if they weren't happy with you just by leaving or maybe going out and spreading rumors if they have situations. I had a client that passed away suddenly, and their key employee was to take over the business, but there was no plan put together, unfortunately. And so the key employee didn't like the terms that were presented to him. So he started going to industry meetings and spreading rumors about how he was going to basically tank the business and then buy it for pennies on the dollar. It can happen. It happened in the situation. We would have been a lot better off if we had some kind of a non-disparagement kind of an agreement with this employee. So employment agreements aren't just for recruiting and getting people on board. They're to protect in case something happens to you with regards to the business. So identifying your key employees, understanding them and their needs, and talking to them about what their future goals are. Maybe they don't want to have the responsibility of running the business someday, and maybe they do. But I have a lot of owners that say, you know, I want to sell it to my key employee down the road. Nobody's ever asked the key employee, do you want to run the business someday? It's a difficult conversation. It's not in the normal day-to-day between business owners and their employees, but someone needs to come in and talk to the employee about what are your goals, what's your ownership aptitude? Do you want to run this business someday? Communicating with those key employees and letting them know that if they do want to run it, that a plan's being put together and there's something in the works, and it might be a stepping stone to engaging those key employees. We find are things like stock appreciation rights, which are a form of phantom stock, which is really a contractual alternative to offering someone stock in the company that keeps them engaged and feeling like an owner and knowing that they have a stake in the outcome down the road. That goes a long way to retaining those key employees that might have been with you for 15 years and they're wondering if they want to stay for the next 15. The other thing that we find is that a lot of times owners will pay a bonus to someone as compensation, but there's no strings on that bonus. So guess when most key employees tend to quit the company? The day after after the bonus cleared in their checking account. So we find a big trend towards what we call controlled bonuses, where you make part of the bonus in cash, it's spendable right away, and part of the bonus has strings that say if you leave the company, you can't spend the money, and you may even have to pay back the money that we basically advance to you under terms of a contract that's put together. So when you it's a tight job market. If you haven't taken steps to retain your key employee, be ready for your key employee to have a unpleasant conversation with you at some point, because I can guarantee you they're getting calls from headhunters in this tight job market. Harry, back to you.
Yeah, thank you, Bill. I agree with that so much. And so as promised, I have a few more tidbits along the way in helping to protect businesses. So let me tell you the next thing we see, many times is that the business itself, and we're going to talk about the real estate associated with the business in a little while, but the business itself will represent many times 75 to 80% of the owner's net worth. Besides the fact that there are estate tax ramifications, aside the fact and then when you look inside the business, here's what we see. So when we have a liability, this is now an internal liability, a liability that's coming as a result of an employee, for example, running out to the pizzeria to pick up a pizza because it is another employee's birthday, and on the way back to bring that pizza back to the office, they ran a red light, had engaged in a horrific automobile accident. One person was killed and one person was injured while within the scope and course of their business. And usually there's probably inadequate insurance to cover that all the way. So then we look to the assets of the business itself and take a look and see what assets we can get. Now, what we have seen is the following things. We've seen large corporations or medium-sized or small corporations, whether S or C, that have inside that business's assets, accounts receivable. They will have very important today, intellectual property, patents, trademarks, domain names, all the things that we used to call goodwill, the thing that gives the business its personality. So they'll have all of those licenses within that corporation. They will then have a large amount sometimes of equipment within that corporation. that's used in the operations of that entity. And then on top of it, on occasions, although usually 99% of the time wrong, we'll even find real estate sitting inside the corporation or the building that's owned where the business is operating. So here's what happens, guys and girls, when we have an internal liability, then when that car crash occurs, or a wage and hour lawsuit, or sexual harassment or claim comes against the company, immediately all of those assets inside are subject to the claims of that particular creditor. So client will turn around, or one of our clients will turn around and attempt to move the excess cash. They may be holding an extra $200,000, $300,000 above the needs for their working capital. They may be holding money to pay taxes, for the entity. That money is now all tied up. If we bring that money outside of the entity and a judgment comes against the entity, they're going to bring that money right back into the entity. So one of the things that we work on, and there are several ways of accomplishing this, is either through a parent, mostly through a parent and subsidiary arrangement, where we have the intellectual property, for example, housed and walled behind its own entity, and then licensing that entity to the operating company, licensing the intellectual property, and maybe even to some other companies that want to perhaps participate in the utilization of their intellectual property. And now if I have, for example, a liability that comes up as a result of that crash, and we can just multiply this for the other assets that we talked about, it should be to the operating company, perhaps it's accounts receivable, but the valuable intellectual property may not be touched by the creditor, or the business, the equipment is not touched, or the real estate is not touched. So I think it's really important that we don't have all our eggs in one basket, which we see all the time. So it's very, very important to restructure the business in such a way that, one, we can't lose control, as I said earlier, and two, that we have some diversification on some internal walls the way the business is structured. This is very, very, very good business. And when people come to perhaps purchase your business, they may be able to purchase a subsidiary from you, or they may be able to purchase the entire holding company from you, but at least they will recognize the nature of the sophistication of the owner, the steps you have taken to protect your business, and that translates into true value. Bill?
Great stuff, Harry. In my level 4, what I found is that we're talking about how do I, grow my business, get my life back. I break it down into 4 different variables here. Number 1 is, and I mentioned this a little bit before, know and grow your value. Know your current value, what your business is probably worth to the market. You don't have to spend $10,000 to get your valuation on an estimate basically for this. We have modeling programs we use basically that come up with a value estimate, and that's good enough for a lot of planning up front. Second is knowing what your future value is, as I mentioned before, so that you know, okay, here's where I am today. Where do I need to be to sell this thing so that after the tax planning and after the tax impact, I'm whole financially and I don't have to worry about ever, regretting selling my business at a time. Next is focusing on what we call value builders. And we have a program where we have identified 8 key value drivers. And what's cool about this program is it allows you to rank how you see your business, and you can even have your other co-owners or key people rank how they see it and have a great discussion and focus meetings about how you're going to work on these different value drivers that rank low and make them rank high so that your business is more valuable and sustainable. And the other thing is that what we want you to do is we want you to go from overtime president to part-time CEO. And what that means is identifying what you do and what you should not be doing, and clawing back some of your time so that you can work on these value drivers and really work like a CEO. When you think about it, if you were the CEO of a Fortune 500 company, there's a lot of things that you do right now that you would not be doing. You'd have people to do virtually all of these things. Your focus and your vision is on growing shareholder value. And basically, we find that a lot of business owners, after working with us for a couple of weeks, really enjoy the fact that they start to get more time back in their day because somebody has said, that's enough of that. You don't need to do those tasks anymore. Or you can develop your standard operating procedures and hand these things off. So now you can really start focusing on working on those things that drive the value sustainability and transferability of your business. So level 4 is all about CEO work and figuring out how to get to a point where you feel like the business isn't running you anymore. You're running the business, and you have a good handle on all of that. Back to you, Harry.
Well, if that's really, Bill, this is just amazing stuff. Every time I hear it and talk about it, I mean, I own my own law firm, and all of it's applicable to me just as much. And hopefully we've taken the appropriate steps as well. So no, we don't have the shoemaker's shoes. So, but there are other questions that I hear all the time, and I'd like to be able to give people better answers. So if we have a liability, we've even taken the steps. We have made the holding company, we've segregated the assets, and now we have a liability that comes up to the business. So my client will say to me, well, Harry, is my personal bank account safe? Is my house safe? Is my real estate and my other investments safe? I mean, after all, that's why I formed a corporation or a limited liability company in the first place. And so my response to them is, perhaps. And they say, what do you mean perhaps? They wanted a question of certainty. So I think there are two things that are important. It's very important to have things structured properly and professionally legally. But I think it's also very important the way in which we run our businesses and the conduct within our businesses as to whether or not those structures that we build will withstand something which is, you've all heard colloquially at cocktail party talk, piercing the veil of limited liability, whether it be an LLC or corporation. What I'm about to tell you is the same. So how do we go about doing that? And understand something else, that most courts around the country and most judges do not wish or do not like to pierce the veil of limited liability entities. That's why they're there in the first place. So we need to make a case. And sometimes, ladies and gentlemen, you make the case for us. So let me turn around and explain how that case is made. Well, in the event, in dealing with a corporation, one of the first things we'll ask for are, can we please have copies of the corporate books, the minutes, the shareholder meetings, the board of director meetings. They should be in good order. We find about 75% of small to medium-sized businesses have not even done that. If you look at your state law, it doesn't say that, this is something that is good option, this is, good business practice. What they'll turn around and say is that this is a mandate that must be done. But unto itself, as a facts and circumstances test, it might not be enough to sink the ship. But still, we need to make sure that's done. One of the things that we have with a limited liability company versus corporation is we can dispense with those particular formalities, which I think is very helpful in preventing piercing of the limited liability veil. The second issue that we look at is, whether or not personal expenses are being paid from the business. We see that way too often, groceries, personal expenses, refrigerator for the house. We took a company check. That's a no-no. Businesses don't need those types of things. We take a look and see whether Uncle Benny, who doesn't work there, is on the health insurance plan of the business. We turn around and take a look and see whether a spouse who's receiving a salary, usually equal to the amount that they could put away for a retirement plan, is on the payroll, but no one at the plant has ever seen the spouse or understand why they're receiving the money, or the children who are working for the summer but really aren't there, or their spouse or the children that are driving company cars but they really don't work there, or that we went on a vacation, basically on a conference. The conference lasted 3 days. We took the family, we wrote off the entire trip for 7 days. Or we have loans to the entity or from the entity that are not appropriately and properly documented. Interest payments aren't made, security interests aren't there. When you put all of that together, and some of it or a reasonable amount of that, you've made the case that this is really not an independent business entity, but it's nothing more than your alter ego because you failed to follow the rules. I can't tell you how critically important that is, and that's why my answer is it depends. If you have treated the business as a separate entity, and there are a lot of ways to do all of these things properly and appropriately, then the protection of that particular business should hold up. And especially when we have 4 or 5 different businesses under a diversified program, we want to make sure we're operating them correctly. So that's a jewel number 3 for you, and we'll kick it back to Bill, who has more goodies for us.
Okay, so here's a fun fact. Of all the businesses that approach a business broker or a M&A intermediary of some type to sell, for every 10 that approach one of those individuals or entities, only about 1.5 actually sells. We have a crisis facing us due to the baby boomer numbers that are coming up. You know, there are 10,000 people, 10,000 baby boomers turning age 65 a day for about the next 15 years in the baby boomer world. That's a lot of people that are starting to think about, how am I going to sell my business? That's a lot of business owners that are getting ready to go to market. We also, within some of the groups that Harry and I are very involved in, we hear from top economists that are saying we probably see some little bit of rumbling in a recessionary period in the short term. The rest of the period after that looks pretty good until 2030, which is a nightmare because that's when all the baby boomers will be on Social Security and Medicare and taking about half the government's budget, assuming the government is reopened by that time. Now, we have a big problem here, and that is that these economists may or not be right, but they're telling tens of thousands of business owners their opinions on these issues, and they're going to drive a trend where a lot more business owners are going to be saying, I want to sell my business before 2030. Well, you better think more like 2025. And so that's why there's a trend starting right now that I call the drive to 2025. And that is that a lot of business owners are going to be saying, while the economy's strong, while the economy's good, I'm going to get it ready and try to sell. And the problem is that puts a lot more contestants in the beauty contest. So that 1 out of 10 number I just told you, or one out of 10 sells that tries to sell, is going to be something like more like 1 out of 25. And that means a lot more businesses are going to have to be structured to sustain themselves with current management. They're going to be insider transactions. And a lot of people say, well, I'll sell my business to an outsider when the time comes. That may not be a best option for you. So you need to start thinking about who's on the inside that can run the business effectively, and what's your tax planning going to look like, because your business is going to finance your own exit. And so when I come back, I'll talk a little bit about some tax strategies that we see that business owners are starting to look at very seriously to address that issue. Harry?
Well, thank you, Bill. It's so important. Those facts they're actually startling. You know, when I look at businesses and we look at business succession and the cross point between business succession and asset protection, what comes to mind immediately is that for multi-owned firms, or firms sometimes that are singly owned and have a strong group of management, is the proper utilization of buy-sell agreements. And when we talk about buy-sell agreements, I like to change the name of them from buy-sell agreements, because sometimes they're really not so much involved in buying and selling. What we're really driving at is control. So I look at them as control agreements. So to make sure that I may be able to work very effectively with Bill, but I might not be able to work very effectively with Bill's wife or the guardian of Bill's children. Or in the event of Bill's incapacity, I'm really no longer working with Bill. I'm working with the person that has stepped into his shoes to make the decisions on his behalf. It's the same as if I had a new partner or a new co-shareholder or a new LLC member, even though nothing has actually changed. So I think it's really important to put together really well-written, comprehensive, up-to-date control agreements that deal with the issues of what happens in the event of death, what happens in the event of incapacity, and how do we define that? What happens in the event of a divorce, like the Amazon guy is going to have a very expensive one, Bezos. I think that it's what happens if one of my partner turns around and has an alcohol problem and no longer shows up to work and is now bringing disparagement to the organization? What happens if somebody dies and the other people don't want to sell them? What if there's no market? How am I going to be forced to work with people? I think it's critically important that we have an agreement. It's well written. And this is an interesting disparagement perhaps on my own industry. About 75% of the control agreements that I read really fail in so many ways. Fail in the way in which the price for the business is determined, fail in the way in the process of which a buyout takes place. I've seen people who bought insurance to cover this, and then the insurance was not hooked into the agreement. So just so many things. Now, what's really important also is when you have these agreements, when one is going for a line of credit, one is going to look for an investor perhaps to come into the business, or a banker, they will ask for your succession plan. They want to know what happens next. So Bill has developed the succession plan. Harry and team have developed the legal documents to carry out that succession plan and the financing for that. And believe me, your opportunity to get investors and financing went way up. So I think that that's a very important kernel from not only an asset protection, but a value driver for the business. Bill?
Yeah, and that leads me to my next segment is about finding advisors that work well together as a team. You know, it's really important that you have a group of advisors that talk to each other, know each other, respect each other, share ideas with each other, and not constantly fight back and forth. Advisors are, it can be very. I often say, advisors are better golfers than they are basketball players. They tend to stay to themselves. They like their ideas. They don't like anybody else's ideas a lot of the time. And when you find an advisor that works together with a team of other people, and again, Harry and I are both very well networked in the advisor world here in Orange County, groups of advisors that are all over the country, tens of thousands of advisors that start off with the idea that they're going to work together as a team. It's important that your advisor doesn't shut down good ideas because a lot of times I'll find they'll say no before they say, I don't know. And that's a problem. You need basically an advisor that says, yeah, I've worked with so-and-so. I know them. They know me. We've done this together. We've done this type of work, so we can help you. And have your team of advisors meet with you together at your that's how you know if your advisors might not work together, if they've never met each other, or if they've never met all together with you to work on strategies with you. So I think it's critical that you have both a team of advisors that work well together and either a quarterback document or planning process where they're all working from the same overall planning document, so that it's you're not constantly wondering, that they're doing what they do in the dark and nobody knows what each other's doing. And it's a comprehensive process. And I think it's really important that you approach it that way and work with advisors that work well with others. Harry?
Thank you, Bill. The team approach is critical. Bill and I have been working together for numbers of years, and it's a thing of beauty when you have your advisors working in concert on your best benefit, and professional jealousies don't get in the way to your detriment. So that was a little commercial in there, but one of the next areas that I want to talk about a little bit, these are things that I see all the time, and they really surprise me. And one has to do with real estate, and in the real estate where the business is located on many times. So I will see a business that, for example, let's say did everything right. They had a holding company. They had the diversification by lines of business or by nature of assets. They were properly structured, properly state structured, a limited liability companies, multi-member, and the business looked right. They had all their forms and their records and their state administrative things in line. And they will operate that business, sometimes out of the owner being a very smart owner, had purchased the land and the building that business operates out of. And the owner did not purchase it in the name of the corporation. But what I will see in so many different instances is that land in that building, surprisingly enough, flaws me, sits inside that owner's living revocable trust. And the lease from the business is that with the living revocable trust. Let me talk to all of you a minute about the ramifications of that. So if there's a liability on the premises, every employee, every vendor, everyone who's coming in and out, every invitee, every guest that's coming in and out is a potential liability. And the failure to provide adequate security for an employee or a patron may not fall just to the entity, but may also fall very much to the owner of the land and the building. And in a situation like that, what will happen is that the lawsuit would go against the owner of the building. The owner of the building would be the living revocable trust. The living revocable trust, as I said earlier, provides no asset protection. And if the business, so now not only do we potentially lose the real property, which is sometimes has very, very significant value, especially in California, but we also can lose our house. You know, in California, we can, if we have a corporation, the stock in the corporation can be gone as a result of a liability of landlord-tenant. And if those of you don't know it, in California and in many other places, the bias is definitely in favor of the tenant and not in favor of the landlord. So landlords need to take strong steps to protect themselves from the claims of those that are on the premises, you know, whether it be environmental actions or mold actions. It just goes on and on and on. So I think it's very, very important to make sure that our land, which is subject to two forms of liability moving up from the operations of the land, and two, liability to the owner of the land. So once again, if my spouse crashes the car, kills a couple of people, and I own some land, that land will be taken away in order to satisfy that claim if it's inadequately insured or don't have enough insurance. So it's important that the land be structured into an appropriate limited liability company and appropriate leases be in place. So therefore, what will happen is that if there's a liability on the land, hopefully it will end the value of the limited liability company and not get through to the corporate stock, my house, my bank accounts, my brokerage accounts. I think that's very critical. And in reverse, should it's one of the owners of the land have a liability to them personally, if structured properly, that plaintiff should not be able to reach inside and take the land away from them. So the land is protected in both ways. And I think that is very, very critical and very, very important. And I think that we also see people talking on that same genre who put 4 or 5 pieces of land into one limited liability company, which doesn't seem to make much sense, because then the landlord has the value of all 5 of those entities combined, and all of the invitees and guests and employees that work in those 5 places are all against a larger pot of equity. I know we all don't like to spend money on extra LLCs or do extra tax returns, but I think it's absolutely critical if we want to be a landlord. You know, it doesn't take much to pass that through to the lease to do it properly. If we don't do it properly, then I don't think we should be a landlord. And let me kick it back to you, Bill. I think that's a very important component. I have one more small component to deal with on my last segment.
Yeah, and my last segment, Harry, is about all that you've worked for can be taken away by improper tax planning in a big way. We're not tax specialists here, but we know the strategies to talk with your tax advisors about. I know between the two of us, we can probably talk about 10 tax strategies that we see commonly. And you should know about these and know about what they look like, and be able to talk to your tax advisors about them well before you pull the trigger on selling your business. In many cases, it's imperative that you put things into play before you sell your business, and or before you transfer it to a child. How do you set up income streams if the business is financing your transaction? If it's an insider transaction to your kids or whatever, what are all of the different strategies you should know about and map out and work with your tax advisors in concert with your advisor team, so that a good chunk of your hard-earned proceeds don't go back to the tax man. So I'll leave it at that, Harry. I don't think we need to beat that one to death, but we're well versed in all the different types of strategies that we can work well with your tax advisors to bring things out. And a lot of times we find that people say, well, nobody told me about that. It's like, well, a lot of times advisors will do exactly what you say, and maybe that's not exactly what you need. Harry?
All right. Thank you, Bill. That's so true. The last item I want to talk about on my side before we open up for questions, it has to do with another issue that I see that actually sometimes has been fatal to a business. So here's what we'll see. We will see that people have engaged in appropriate and proper estate planning, and they've created wills and trusts and advanced healthcare directives and powers of attorney. I think it's really important in powers of attorney that we think about who is going to be the person or persons that are going to run the business, which may be different from the persons that are going to run the personal assets that we own. So we might have bifurcated powers of attorney. So we have a good people there to run the businesses in the event of our incapacity. We traditionally see, a spouse or a child that really may not have the capacity to do it. And that could be the end of the business. So our succession plan could be short-circuited very, very simply. But the other thing that I see that I find very interesting is that I will see these most comprehensive estate plans set up, a lot of money spent to put them together. I will see a home that was then transferred into the trust. I will see a bank account, a brokerage account transferred into a trust. And then I'll take a look and see that the limited partnership interests, the limited liability company interests, or the stock in the corporation, if they have one, was never transferred into the trust. So in the event of a death, what happens is all of those interest, which is sometimes representing, again, 75 to 85% of someone's net worth, are traveling through a probate process in the state, which could take anywhere from 18 to 24 months and cost 8% of the gross probate estate and open up everything to the public. It's very difficult for a business to survive that. And that would have been so easily resolved on a legal audit that we would have picked up and noticed that the major asset was never assigned to the trust. Now, that has nothing to do with specifically asset protection from the claims of a creditor, but it would be asset protection because the business could literally fail while going through the probate process, and that ends the succession as well. So I think that it's the combination of a great succession plan combined with appropriate estate planning and asset protection planning leads to the greatest value for the business and best shot for making it from generation 1 to generation 2. And then from my end, that's what I have. I'll take any questions. And Bill, do you have anything to close on the remarks on that as well?
Great. This is Paul. I am getting some questions. You want to jump into those now?
You bet.
Why not?
Yeah, okay. And I want to remind all those in attendance that for everyone that's jumped on, we offer a complimentary assessment with Harry and or Bill. The assessments are great. Take a look at your current situation and give you some one-on-one feedback from our experts. So we will email everybody as a follow-up that information, so look for that. But Harry, I'm going to start with you. This question came up from one of our attendees, interesting one. Sounds like that he or she is running an Airbnb business in another city, Hawaii, and lives in California. The question is where to set up the business, in Hawaii or California, and what's involved with that?
Well, that's a very, very, very good question, but we go more than Hawaii and or California. I think the first thing to do is the business, which needs to be a limited liability company, should be set up in a state's law that is the most protective for the owner of that LLC. Hawaii is not bad, but there are better states. Nevada is better, Wyoming, South Dakota, Alaska. So we could use an Alaska limited liability company or a Nevada limited liability company and then authorize that company to do business in Hawaii. So it does need to be, no matter what, it's a Hawaiian LLC authorized in Hawaii or a LLC in Alaska authorized in Hawaii and perhaps California if it's managed out of California. But on whether it's created in Hawaii or whether or not it's another state and the business is in Hawaii, Hawaii needs to, the LLC needs to be registered in Hawaii.
Great, good information. Bill, this one's for you. And this is Julie in Texas is asking, she says, and I'm paraphrasing here, that succession planning is it's a big phrase. How does one get started?
Well, I start with 3 questions, and that is, what's your, I call it the 3 T's. What's your timing? When do you want to either go from overtime to part-time and be out of the business some days? So what's your timing? So the second T is, what's your target? Who do you want to, in your plan A, who do you want to take over the business or sell the business to? And I also like to see a plan B there as well. And number 3, I call it the third T is treasure. What do you need to get out of it? And then if we can quantify, well, let's figure out what's the current value and what you need to get out of it. Then we can start to see what kind of work we need to do with those 3 T's, timing, treasure, and target. we can really start to get a plan kicked off.
Nice, nice. Harry, back to you on this one. When you were talking about the liability to a business owner, the question here centers around somebody who's got a partner, so they're co-owners of a business. And the question is, does this mean I'm exposed to the liability of my business partner and everything that's going on with him?
Well, I think you have that. That's a really great question, but it's also quite a complex answer to do it effectively. So let me take a stab at it if I can. So we have to go by form of business. If we have a general partnership business partner, then both partners are joint and severally liable to the full extent of their net worth. So if one of the partners engages in an activity that brings disparagement, both partners could lose their homes as a result of it. In the form of a corporation, well, what would happen is if the partner who's really not a partner anymore, is a co-shareholder, has issues or problems or does some outside business deals that create some problems for them, the issue that comes in is that now they come in and they are able to take away your co-shareholder stock. So all of a sudden you wind up with a new owner, a new co-shareholder along the way. That could be absolutely horrible, devastating, and could be the end of the business. And if you don't want that, then you're going to have to buy that person out, but there's no insurance for that. So now we're going to have to try to enter into negotiation. We're getting valuations. Very, very, very difficult. So I think it's really important to have a structure of a business in such a way, which is done in an appropriate limited liability company, where the acts of the partner or the member outside of the business would not change the managerial control of the business. So that's a really good question, and we've seen that happen so many times. So it's just a question of structuring before the problem arises that can mitigate that and make that go away.
And Harry, I don't think a lot of people really think about that. It's not an issue that comes up.
And hopefully that's why they're on this webinar.
Yeah. Bill, back at you. We've got a ton of questions. This might be our last one because of the timing. What if you're not sure who your successor or sale target will be yet?
Yeah, that's a common situation I run into. A lot of business owners that say, well, my son or daughter, I'd like to consider them for down the road, but I'm just not sure that they're up to it yet, or they're just not they're not showing owner aptitude or attitude at this point. And so a lot of times it's a question of discussing the situation with that target successor and really finding out if this fits into their goals, if maybe they can be put on a glide path to become that person, or at least given an opportunity. Basically, I work with a lot of owners that say, look, let's put your kids on a path and put them through like a college course. Let's teach them how to think like an owner. Let's get them learning about the business from the inside out. And if they don't graduate, if a year from now they're just not showing aptitude or they're not engaging in that, we probably get our answer at that point and we can look for plan B. A lot of times key people might be the best target to take over, certainly in an emergency, but they may not have the money, so we can put them on a path towards doing more and earning money that they don't get currently, but it's put into an account or on the books for them down the road so they can have a down payment and buy into the business. So there's really, that comes up a lot, and I think it's important to do the best you can. You know, I mean, come up with a plan A and a plan B, think about it, see if what work needs to be done, and if not, then we really can start looking at, well, let's get it ready for sale to an outsider.
Excellent. Bill, Harry, great information. Thank you very much. For all those in attendance, thank you. Look for the follow-up email, and we'll see you next time.